Okay, so according to my clock, it's 10:35, so let's get started. Good morning, everyone. This is Whit Clark. I'm the Deputy Secretary of State for Business Development at the Department of State, and this is a meeting of the New York State Board of Real Estate. So thank you for joining. Because of the ongoing public health crisis, Governor Cuomo has issued an executive order, 220.1, that suspends provisions of the open meetings law. So this meeting is being held by conference call, which is a change for us. Interested members of the public are able to call in and listen, and the meeting is being recorded. So I would ask everybody to keep your phones on mute to eliminate background noise other than when you're speaking. And I want to confirm that everybody received copies of the meeting materials. They're attached to the meeting invitation. Does anyone not have them? Okay. Let's take a roll call. Greg Weston. Greg? No. Tricia O'Connor. Tricia, are you here? No. Dale Burnett. Dale?
Yeah.
Dale's here? Okay. Thank you, Dale. David Dworkin?
Sure.
Okay, David. Raquel Vasquez? No. Diane Ramirez?
Present.
Good morning, Diane.
Good morning.
Sandra Erickson? Sandra? Nope. Duncan McKenzie?
I'm here, Whitney.
Good morning, Duncan.
Good morning.
Neil Garfinkel, I heard your voice.
Yep, present.
Okay, Dirminder Basan? No. And Edwin Clark?
I'm here.
Good morning, Mr. Clark.
Good morning.
So, David, according to my tally, we have 6 board members present. Do we have a quorum?
No, we would need 7 members for a quorum. There are 15 members total, 2 vacancies. Majority of serving are required, so we would need 7 of 13.
We need 7 of 13. Okay, well, let's table the first agenda item then, which is approval of the meeting summary. If another more board members join, we can vote on that at the end. So jumping into action items, the first item is an enforcement update from our Deputy Chief of Enforcement, John Goldman. John?
Good morning, everybody. So I'll just kind of expand on that a little bit. So in addition to, I'm going to go over 2 items. I'm sorry, I didn't mention the first item. So I was asked to kind of brief the board on 2 kind of dominant items that have been in the press lately, which of course is the executive order cases, executive order, the stay-at-home order as it relates to the real estate industry, and we do have some enforcement activity that I'll brief you on. But before I go into that, I'm going to talk about the Newsday investigation report that came out in November, which, unless you have been living under a rock for the past 4 or 5 months, I'm certain most board members are familiar with. So right around Thanksgiving, I think it was shortly after Thanksgiving, just despite everyone's likely familiarity with the situation, I'll just give a brief background. Newsday, the predominant print newspaper on Long Island, published what really was somewhat of an unprecedented story focusing on the real estate, the brokerage industry on Long Island, specific to Long Island, Nassau and Suffolk counties, and related to what they described as they thought was a pattern of clear-cut discriminatory practice in the real estate brokerage industry in terms of how, the 2 groups are minority purchasers, home buyers, and specifically these are all sale. They were talking in terms of sale transactions, that home buyers who were who were white and how they were dealt with by the test subjects, the licensees that were the subject of the Newsday test, compared to how minority buyers were treated by those same testers. So you had pairs of tests where the same agent was targeted. As I'm sure everyone knows, the interactions with the targeted agents and the testers were recorded by a hidden video camera. And then Newsday's story basically outlined the disparity between the way the white tester was treated in terms of properties shown, communities they were shown properties at, kind of guided to, compared to how the minority testers were treated. So when this story came out, obviously DOS licensing noticed, was very concerned. We spent quite a bit of time studying the story, communicating with necessary parties. If you look carefully at the story, Newsday identified 34 different pair tests where agents were tested, again, with a white purchaser acting under a pretense, acting as a purchaser. These were all obviously representatives of Newsday acting on behalf of Newsday. There were a total of 34 tests. We studied the article, the story, the investigation very, very carefully. We determined that there were 27 of those 34 tests that we were concerned about. They varied in terms of their obvious concern relevant to the agent's behavior, what they did not do, said, did not say to the testers. So we eliminated 7 as in terms of we felt that 7 of the highlighted 34 tests were such that we were not overly concerned regarding the behavior, what the agent did not do, did not say, said, et cetera. We started at a level of 27. We were concerned to one level of degree or another with 27 of them. We then triaged these cases because there were some of these cases, these tests, that we were far more concerned about than others, and we felt that was the appropriate enforcement posture to take, so we wanted to act upon and focus on the ones that we were most concerned about. We triaged them level 1, 2, and 3, triage 1 being the most concerning, obviously 3 being the least concerning. Nonetheless, there was some concern, but we were least concerned in some of them than we were in others. So we triaged them. We felt that was the appropriate posture to take in terms of our investigation activity. We then focused on the triage ones, scheduled interviews. They were all in-person interviews in our New York City district office because that's the majority of our enforcement staff. Again, these licensees practice in both Nassau and Suffolk counties, and so the interviews were all in person, involving both the agent that was the subject of the test and, of course, the brokers of record of the brokerages that sponsored those agents at the time of the tests. And so they were interviewed in person as well. As far as a breakdown of the 27 cases, we triaged 16 as 1s and the remainder 12 as 2 and 3. So it was a little bit north of half where we felt we were seriously enough concerned that they would be labeled as a triage 1. So this goes back to November. We're now on the verge of turning into May, so several months have gone by. So up to this point, we have completed 11 of these investigations, and they've been referred to counsel for potential disciplinary action. Obviously, we felt there was some merit to the Newsday angle. We also took the opportunity to look at some other aspects of the practice of the agent, continuing education, and so forth. So 11 of them have been completed. They are pending with counsel. The remainder of the 27 are still pending investigation. Obviously, the COVID situation has somewhat hampered our progress, or certainly made it difficult, but it by no means has come to a halt. We're still moving forward. So the balance of those 27 are still pending investigation. One salesperson did agree to surrender her license, equivalent to a revocation, based upon the situation, the scenario, the outcome of the investigation. So that, in a nutshell, is kind of the summary of where we are at. The 11 that have been submitted in pending investigation, the majority of those are the tier 1s. There's a handful of them that include the tier 2s and the 3s. We are focusing our efforts on the ones, again, because we felt those were the most concerning, and so those should be wrapped up relatively shortly, followed by the balance of the 2s and the 3s. So the other situation that I was asked to brief you on were the executive order cases. So following the late March various versions of the executive order, how it impacts the real estate industry, the state, the Department of State received numerous complaints, allegations of violations of the executive order for the various disciplines we regulate. As far as the real estate brokerage industry goes, to date, it's been a relative small amount, which is good news, that overall the industry is complying with the order. There's been a total of 6 complaints. They all 6 of them fall under one of 2 allegations, either that the office or a office is open and staffed and is operating contrary to the executive order. The majority of them, however, are allegations that an agent or particular agents of a broker were out and about showing properties, which is also a violation of the executive order, which requires all activity to be done remotely. As far as location of these complaints, the majority of them are in Manhattan. They also include Nassau County, Otsego County, Schoharie, Tompkins, and Ulster County in the Hudson Valley. That's the extent of my comments this morning.
Thank you, John. Does anyone have any questions for John?
Whitney, I just want to confirm before that I have been on since the beginning. Sandra Erickson.
Thank you, Sandra. Excellent. So we have a quorum.
Hi, Whitney. This is Duncan. I have a question. I've heard reports that that folks from a 518 area code have been calling brokerages and asking them to do an in-person showing. The impression of the agents who received the calls was that this was a Department of State tester. Can you confirm that?
We have not been doing any testing, Duncan. To the extent that those calls are being made, they're not being made by Department of State enforcement.
Thank you.
This is Dale. I was just wondering if you could talk a little bit about just the investigative process. We're a bit distant from it, but, how did you determine, whether or not practices were discriminatory? There's sort of the letter of the law, if you will, and then there's just nuances about when people are being prejudicial. And, the concern I would be getting at is just sort of what body convened around this, and how did we ensure that there was just diversity in thought about whether or not there was discriminatory action?
Sure. So as part of our disciplinary process, there really are 3 phases to it. The first is investigation, which is really just a fact gathering, an evidence gathering component. So we have 24 investigators throughout the state. So when we receive a complaint or we have a concern, the investigators interview the relevant parties, collect documents, and write up a report summarizing the results of the investigation. From there, the file is sent to our Office of Counsel, and that's where the determination is made about whether or not there's a violation of law. So we have referred several cases to Counsel's Office as a result of the Newsday investigation, and those are being reviewed by our attorneys. Dave Mossberg is our program counsel. He's on the line. So David, could you give any insight into what you look at specific to fair housing allegations?
Certainly. So we have the benefit in these particular investigations of working with the Division of Human Rights. They're also part of a resource for us in doing these reviews. And so we've actually obtained sort of case law history, sort of like trial preparation materials from them in helping us determine how we might be able to analyze these facts and investigative reports to determine whether or not we think there may have been some sort of discriminatory conduct. We're still reviewing the information currently, so we haven't yet made any final determinations as to whether or not we think, a particular broker, acted in a discriminatory fashion. Some types of discrimination are easier to establish from, a legal point of view in terms of demonstrating, by substantial evidence, which is the legal standard we use in our enforcement proceedings. So, for example, in some of the investigations, there were more sort of like overt and clear differences in the treatment between the two testers, in terms of where they were being shown property in terms of geography, or, specifically not presenting a property that, the reporters had indicated were available only a short time while ago to a different tester. So those cases are, a little bit easier to establish that there was discriminatory intent or discriminatory aspect to the treatment. The other types of cases are a little bit more challenging to establish, but, we're currently reviewing the information that we've received from the investigative unit. What will happen afterwards is, once we're done with our investigation review, a formal complaint, which is just, a series of allegations from the department and our attorneys, which will inform the license holder that, we believe that there's substantial evidence of a violation. We have to articulate the reasons why we believe they discriminated. They'll get that complaint, and then the matter will be scheduled for a hearing, potentially before an administrative law judge, where then it'll be up to the judge, based on, applicable case law as to whether or not there was discrimination, and then the judge will be responsible for fashioning an appropriate remedy. So hopefully that answers some of the questions.
Okay, thank you, David. Does anyone else have any questions on John Goldman's enforcement report? No? Okay, moving on then to the next item under action items, the status of continuing education requirements. Amy Pensadine.
Good morning, everybody. Included in the documents that we provided to the board members is a copy of the text of the statutory amendment to the real property law that changed the real estate continuing ed requirements for licensees. The law was approved in October of 2020 with an effective date of July 1st of 2021. This provision changes a few items. Out of the 22.5 hours that a licensee must complete, the law adds a provision that 2.5 hours of the required CE pertain to ethical business practices and 1 hour pertaining to recent legal matters governing the practice of real estate brokers and salespeople. This may include topics such as statutes, laws, regulations, rules, codes, Department of State opinions and decisions in court and court decisions, which these courses, this 1 hour of legal matters must be taught by an attorney in accordance with our regulations. Those additional hours, designated hours are in addition to the existing hours of 3 hours of fair housing and 1 hour of law of agency, with 2 hours of law of agency for a salesperson within the initial 2-year license term. So these go into effect July 1st of 2021. Another provision was that it removed the CE exemption for brokers who are licensed for 15 years. So that exemption has been removed beginning July 1st of 2021. An email blast notification was emailed to all licensees informing them of this change on 12/20 of 19. For the purpose of implementing this change, the date that a licensee must meet this new requirement will be based on their expiration date of their license. So it doesn't, when they go to renew, even if they renew early, it will be based on the date that they expire of what their requirements that they must now meet. Whether you meet the old ones or the new ones would be solely based on your expiration date. Additionally, a notification was emailed to the approved real estate schools informing them of the upcoming changes. They've begun to send courses into the office that meet these new CE requirements. That concludes my report. Does anybody have any questions?
Oh, okay, thank you, Amy.
This is Trisha O'Connor. Good morning. I have a question. So I had sent a message, I think, before that I'm hearing that quite a few real estate schools no longer want to do the fair housing because of the regulations, and I had suggested if there was a standard fair housing. Any thought on that? Like a standard video that the Department of State and the Human Rights of Fair Housing would produce, and that is what the schools would put out to their students. So everyone is getting the same fair housing training. Because I remember when I first started real estate and I used to take education courses, there was a fair housing training that I used to take that was a standard video that showed examples that we would all watch. That was just my suggestion, just your thought on that.
Okay, let me open it up to the board members. What do you think about Tricia's suggestion? Okay, Amy or Denise, do we have a subcommittee for education?
I believe we do, right, Denise? I mean, I know we did for development of the qualifying education as we move forward.
Yes, we have an education committee.
Yeah.
Okay, well, let's refer this issue to the education committee for discussion and consideration. We can report on it at the next board meeting.
Okay. This is Diane Ramirez. A quick question on the new ethical behavior and legal matters. Is that additional hours, or that will be reworked into the 22 hours?
It's within the 22.5 hours.
It is 22.5.
Yeah.
Okay.
Yeah, but it's just specifying certain topics that they have to take. Perfect. Within that. Yep.
And could you let us know who is on the education committee?
Denise?
Yes, I can do that. I can send that out and also see if other board members would like to participate on that committee as well.
Thank you.
Okay, next on the agenda is Dave Mossberg, who has an update on two pending regulations. David?
Hi, good morning again. So we're providing an update on two regulations that the board had previously voted to propose and then simultaneously voted to authorize the Secretary as chair to take all necessary measures to adopt the proposals, obviously subject to receiving public comment and determining, whether or not any revisions to the rule that was proposed by the board were required. And so the two rules that I'm about to talk about, the public comment period has expired for both rules. The department's review of the public comments that were received did not result or require any sort of substantive changes to the actual rule. Although in one of the rules there was a change that we did note, and so I'll be going over that. The first rule that actually is related to the comment just made concerns the fair housing regulations that were recently proposed. On April 21st, the department filed the notice of the notice of the adoption for the proposed rulemaking relating to advanced and enhanced fair housing protections. A copy of the final rule is in the board package material. What the rule did is it added a new 175.28, 175.29 and 177.9 to Title 19. What the rules did first was that it required a new fair housing disclosure form to be provided to prospective clients, being the purchaser, tenant, seller, landlord, upon the first substantive contact. So it's the same standard that the license holders are familiar with, because it's the same standard with respect to the agency disclosure form. A copy of the notice form was also provided in the board package materials. It's the form that looks, or should be familiar to most. It looks similar to the agency disclosure form. It's a 2-page form. It just requires to be provided for substantive contact. Has to be maintained by the broker for a period of 3 years. And it advises basically the individual about the fair housing rules and, you know, where the individual may be able to go to file a complaint, both with the Division of Human Rights as well as the Department of State. The second rule requires a fair housing notice to be prominently posted in all broker offices and on websites maintained by brokerages. It also requires that this fair housing notice be prominently posted at all open houses. It doesn't have to be presented at private, you know, appointment showings of real property, but just at open houses. And again, the poster is in the board package materials. It's also going to be available on the Department of State's website. And it just advises, you know, the public some examples of fair housing discriminations, and also advises people of their rights, and again, where individuals may go if they need to file a complaint, if they believe that they've been discriminated against. The last part of that same proposal concerns places of instruction that provide fair housing instruction, so the 3-hour courses. What that requires is that the providers now ensure that the instructions are audio and video recorded, that the recording is maintained for audit by the Department of State. The rules themselves will be published in the May 6th edition of the New York Register, which will be available on the Department of State's website. And these rules are scheduled to go into effect on June 20th. So again, the fair housing disclosure form will have to start being available and presented by the licensee starting June 20th. The disclosure notices will have to be on websites, in all offices, and at all open houses, again, starting June 20th, and then all courses of instruction will have to be video and audio recorded, again, starting on June 20th. The department plans on advising the industry by sending out an email blast with the forms that are required, copies of the text, and as well as additional, guidance that we're currently still developing to help really explain what the rules require so that the industry is adequately informed. The one thing that I wanted to mention with respect to this rule is that we did make one non-substantive change to the rule text from what was proposed in response to the public comments. It wasn't a substantive change, so that's why it wasn't brought back to the board. We addressed it in the documents that'll be published in the register, but just so that the board is aware, we had removed paragraph E in both 175.28 and 175.29, and that concerned the issue of broker liability. Some of the comments were confused as to how that would apply with other existing statutes, and so to avoid any sort of confusion with the industry, we just deleted that, and we explained that there's other existing regulations that govern the broker liability for salesperson's violations. And so rather than potentially create a, a confusing situation, the department removed it and noted that, those other sections are still applicable because those weren't changed. And so that's how the broker liability will be enforced should there be a violation committed by a salesperson or associate broker in the office. So I'm not sure if anyone has any questions regarding the enhanced fair housing regulations, but if there are, I'm happy to address them before I go on to the other rulemaking.
Ramirez, again, I think I heard you say we received a copy of the forms and whatnot. I don't seem to see that in my file. Is that the case, or did we receive the forms and the
so in the WebEx advisement or the notice that went out for the call-in information, there was a link where all these documents are. They're also on our website currently under the media advisory link for the advisory for this meeting. So everything that I just mentioned is available as a PDF on that website as well.
Okay, yes, I had trouble with the link. That's why I didn't see it. Thank you so much.
Of course. Does any other board members have any questions about the enhanced fair housing regulations? Okay. So the other regulation that I wanted to discuss was the update to the regulations relating to real estate advertisements. If the board recalls, we had previously began to look at existing advertising regulations, particularly with a focus on internet advertisement and certain lead generation websites, both IDX websites, broker websites, as well as third-party private paid platforms. And so if the board recalls, we proposed a fairly comprehensive update to the existing regulations. Again, those regulations were proposed by the board with specific approval for the Department of State to adopt if necessary, provided there were no substantive changes required. And so the Department of State, on the same date as the enhanced regulations for fair housing on April 21st, filed the notice of adoption to adopt that advertising update. We made 0 changes to the rule text. So the rule text as proposed by the board previously was filed for adoption. The final rule text as adopted is on the links for the meeting. It'll be published in the State Register on May 6th. And these regulations will go into effect on November 2nd. The department, when we had proposed it with the board previously and working with the interested stakeholders, we determined that, there was going to need to be time for the real estate industry to understand what the rules required and then also to make any sort of necessary changes to their websites to comply with the rule. The department, we are also working on advisory and guidances to the industry to help them to comply with the rule. We hope to send that out shortly. We're still working on that. But some of the sort of significant things for this rule, if the board remembers, is we updated, for example, the language that was previously required where a broker had listed property that wasn't actually listed with them in a transaction. there was this previous disclaimer that said this advertisement doesn't suggest that the broker has a listing in his property or properties or that the property is currently available. As we had previously discussed, that was sort of very wordy. It didn't really apply in the internet advertisement realm, and so we had changed that. Now there are very clear phrases that the brokers would be using to identify their roles in the transactions. We also make clear how it's to be applied if a broker is going to be relying on a third-party platform to advertise, that they now have to use the word advertisement, or at least the word advertisement at a minimum in the advertisement, so people know that they're paying for that. And we also updated information with respect to thumbnail views or multiple listing views when you're on a website and you're searching for property, and you'll see, like, dozens of properties that show up. The information now has to be displayed on those pages as well, not just the detail page for the consumer. And so, again, we made no changes to the rule. We actually received over 700 public comments to that rule. And again, that rule is going to go into effect on November 2nd. So I don't know if any of the board members have any questions at this time on that rule, but I'm happy to answer any questions.
Okay, thank you, Dave. You're actually next on the agenda, but you've been speaking for a while, so I'll give you a break and go into the approval of the December 16th meeting summary, which is attached to the board material. Has everyone had a chance to review that?
Yes.
Yes. Okay. I'll make a motion to approve the meeting summary. Can I have a second, please?
Second.
All in favor?
Aye.
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 Any opposed?
Aye.
Okay. The meeting summary is approved. All right, David, you're back on again. Executive order.
So this one will be short. So there were 3 executive orders that are, related to the board and their function, and so we just wanted to provide a brief update because various executive orders have been extended for different dates, and we've received some public inquiries about them. And so the first one that I just want to give a mention on concerns the electronic remote notarizations. As many know, in real estate transactions, lots of documents need to be notarized, so EO 202.7 allowed for electronic notarization. That executive order has been extended through May 7th. There was a second executive order which concerns the real estate licensees as well as all the other Department of State licensees, which extended the automatic expiration date of their a license holder's license so that they had additional time to renew. That executive order, which is 202.11, was extended also through May 7th. What that means is they have any license holder whose license expires now is actually pushed through May 7th, and then they have 30 days from that date to actually submit the renewal. That's just the way that the executive order was drafted. So they actually have until June, early June to renew because it's 30 days after the May 7th date. And then the last one, briefly, which I'm sure everyone knows because John Goldman had mentioned it earlier, concerns, I believe it's 202.6 for remote services for non-essential businesses, otherwise known sort of as New York on pause. That one has been continued through May 15th. So that's just the updates that I have on the expiration dates for those EOs.
Okay, thank you, David. Any questions?
Hi, Whitney, this is Duncan. A couple of things. And I know this came out of ESD and not DOS. In their
I can't hear Duncan.
Okay, hold on. Can you hear me better?
Yes. Yes, better.
Okay. So this really refers to what ESD has put out, but I'm just wondering what your information is. In their last communication, in the last executive order, they talked about, or the last time that real estate was discussed as an essential service, they talked about legally necessary activity could continue. That has never been defined by ESD or anybody. We get a lot of questions about that, so any clarification on what that might mean. Also, way back in late March, when ESD was sending out letters to brokerages individually saying they were essential, it's our understanding that some brokerages consider that to survive both of the previous executive orders on April 1st, 2nd, and 9th. Can you clarify that a little bit, please?
I know that we have had discussions with ESD to try to get clarification on the various executive orders. David, do you know if we received clarification on these issues?
I'm sorry, there was an echo?
Yes, David and Whitney.
Is that better? No.
Yes.
No. Slightly, yep.
Yep. No, not better.
Doug, can you please mute your line? Coming from you.
Everyone on mute?
I think there's several lines that are not muted. People who are not talking need to mute their lines. That'll avoid the echo.
Okay, everyone on mute, please. Okay, that seems to be better. So yes, we've been having some discussions with ESD to try to get clarification on some of these issues. Our general counsel has been in touch with ESD's general counsel. So David, do you know if we've received any clarification on the term legally necessary, or whether or not the individual letters issued to licensees survive the subsequent executive orders?
No, not to my knowledge. We haven't received anything recent from ESD on those particular issues.
Okay, so we do have a regular dialogue with them, though, Duncan. So I will speak with Linda Baldwin after today's meeting to see if she can add those topics to the list. And as we receive clarification from the ESD, we'll send that information to the board members and our licensees.
Whitney, this is Sandra Erickson. I just want to add that licensed brokers that are property managers are an essential business, so we are operating.
Okay.
Okay.
Those two clarifications would be huge, because those are two of the really big things that we're getting, and it would be very helpful if ESD could do that, and also if they could be a bit more effective in communicating to the industry as a whole instead of piecemeal, maybe coordinating with you guys for a blast email on these kinds of updates. It would be very helpful, because there's a lot of individual interpretation that goes on, and it's not to anybody's fault, because a lot of it's left very gray area.
Okay, absolutely.
This is David Dwarf. I just want to, restate what was said a minute ago as well. The property management's a big question for brokers that have that as part of their functions, and to the extent that we can get some additional insight and clarification, I think that would go a long way, because that is an absolute gray area right now, that people are presuming that they are essential because they're managing property, but it kind of gets lost a little bit, and any clarification, I think, would serve everyone well.
David, this is Sandra again. I have a very, very good legal statement that I can send to you that states that property managers are essential. So I'll send that out to you.
I would appreciate that. Thank you.
Sandra, this is Whitney. If you could send that to me as well, that would be helpful.
Sure.
Thank you.
It's very helpful. It's very clear cut. So we are all the property managers, of course, that are our brokers. They are all open and operating.
Okay, thank you.
Hi, Whitney. This is Duncan again. Another issue, the live broadcasting of CE courses has really proved to be very effective We're just wondering whether or not that's something the department might consider as a permanent option.
We are, Duncan. I think we received an email from Priscilla last week about this issue. So we're looking into it, and we'll be making a decision probably this week or next.
Great. And then one last question. Sorry to dominate the conversation here. And I know you don't have a crystal ball, but the governor has talked about regional reopenings, certain industries on May 15th. Anything that you can tell us about where real estate might fit into that? All of the 7 regional states that has been kind of created ad hoc, all except for Pennsylvania, do allow, for example, in-person showings, showing with the appropriate safety precautions. I'm just wondering if you guys have any sense of whether or not we might fit into that first wave or where afterwards.
The only information I have on that, Duncan, is what the governor said yesterday, that the first wave is going to be manufacturing and construction. I haven't heard any mention about where real estate will fall into it, but at least internally we're starting to discuss best practices that our licensees should take for when they are phased into the reopening. So, board members, if you have any information, ideas, or research on these issues, if you could please send that to us, it would be very helpful.
This is Edwin Clark. I have a question. Will the real estate be phased in, will it come in phases like upstate? Will we be phased in along with manufacturing, say after May 15th, to loosen up some of the, with precautions, of course, some of the executive order? Obviously, we're not seeing the severity that we're witnessing downstate. So I wondered if upstate real estate is going to be, loosened up in phases, Western New York, I know Kathy Hochul, and then Bob Duffy for the Finger Lakes region. If regionally we're going to be some relaxation of the executive order.
You don't have any firm answer to that. I mean, all I've heard is through the governor's press briefings that they are looking at a regional approach and they are looking at a phased-in method of reopening. So as we receive information on it, we'll certainly let you know.
Okay, thank you.
This is David Dworkin. Also curious, and the answer may be the same, which is everything we've heard publicly, but is there any sense that when they do get to the reopening of real estate, that is it going to be blanket commercial and residential, or is there any discussion, obviously showing a 20,000-foot warehouse, the precautions are a little different than showing a one-bedroom apartment, for example?
I think for internally, as we come up with our suggestions for the best practices, those are things that we're going to be looking at. You really have to assess the risk. Social distance, overcrowding. So if you have any ideas about, certain sectors that would make sense to be phased in sooner than others, or different practices, please give those suggestions to us so we can pass them along to the governor's office.
Absolutely. Thank you.
Okay. The next item on the agenda is the nomination and election of the vice chair. The statute allows the board to elect a vice chair. We have one member who submitted his name for consideration, Duncan McKenzie. I believe Denise emailed his biography to the board members this weekend. Did everybody receive it?
Yes.
Okay.
Yeah.
So Duncan, I've been working with Duncan for many years. As you know, he's the Chief Executive Officer of NYSAR, the New York State Association of Realtors, which is the largest New York State trade association with over 60,000 members. He has in total 37 years of experience working with government. In addition to his position at NYSAR, he's worked in the Assembly and Senate and as a lobbyist, and he holds a Bachelor's of Arts from Union College. Does anyone have any questions for Duncan?
Nope.
No? Okay. Can I have a motion to elect Duncan as the vice chair?
Motion to elect Duncan McKenzie as the vice chair of the board.
All right. A second?
David Dwork.
Okay, all in favor?
Aye.
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 All right, any opposed? All right, congratulations, Duncan. You're our next vice chair.
Congratulations.
Thank you. I'll let you know where to send the check.
All right, so if any board members have topics for consideration or discussion at the next meeting, please email those to Denise so she can add them to the agenda. But for now, I'd like to ask for a motion to adjourn.
Before we go, can I ask?
Hello? Someone just ask a question?
Yeah, I just want to double check if there was any members of the media attending this meeting. Anyone on the call is a member of the media?
No.
No.
I don't see any.
Okay, thanks.
All right, thanks, Mercedes.
Thank you.
Okay, motion to adjourn. A second?
I second.
All in favor?
Aye.
All right, thank you, everybody. Be safe.
Thank you.
Bye-bye.
Bye-bye.